Hello, everyone. Today I'm going to talk about the case at GATT, happened in 1987, that is called Superfund, BISD 34S-136. This is actually a case mostly classified within the environmental law category, but because it is known as the father of CBAM, I believe it worth to elaborate on a bit more, so it helps you understand what we discussed in the class about the CBAM. I hope in the end you can distinguish the similarities and differences between this case and the legal ground of the CBAM. So, so before I start to talk about this case specifically, I think it is important to get into a common understanding about the case background. The Superfund case actually started from a law that the US passed to solve the environmental disaster came up in a region called Love Canal. The story of this love canal, actually, it's not a love story. It begins in 1890s when an entrepreneur named William T. Love, he wanted to establish a futuristic city powered by Niagara River. And to support this vision, he began digging a very massive canal. But actually, the project was abandoned because of some funding issues. So it left a very large hole in the ground for decades. Now, we move forward until we reach to 1942. Here, a company named the Hooker Chemical Company repurposed this abandoned canal as a convenient landfill. So, you know what landfill is, right? Landfill is the area you dump and you depose your waste, like industrial waste. But nowadays, it should be very according to environmental codes and regulations, something that in the 1940s was not as strict as it is now. Anyway, by 1953, the company had buried approximately 21.8 thousand tons of industrial waste, including dangerous carcinogens like benzene and dioxide. So, you know what benzene is. It is actually one of the building blocks of chemical industries, and especially it is known as an intermediate feedstock to create other chemicals, which are then used to produce plastics, resins, synthetic fibers, rubbers, and etc. But because it is actually really toxic, its application has been very much limited nowadays compared to what it was in the past. So, back to our storyline. Once the canal was full, they simply covered the waste with dirt and sold the property to the local school board for just $1 to absolve them of any future liability. Hooker Chemical Company included preemptively guarded clause in the deed, something like this that you can see here in this slide. And they thought that this would save them from any sort of responsibility or better yet liability in the future. So, following the sale, a school and a neighborhood of hundreds of families were built directly on top of the toxic site. And by the 1970s, the situation had turned into a full scale nightmare because heavy rains caused the corroding waste barrels to surface in the people's backyards. Residents started noticing strong chemical smell, and then children were even being suffered by chemical burns from playing in these contaminated puddles. So, more alarmingly, there was a clear pattern of miscarriages, birth defects, I don't know, serious illnesses in the community from different sorts. And eventually, investigation revealed around 82 different chemical compounds, 11 of them known carcinogens. And these were all seeping into homes and basements and almost everywhere. So naturally, this led to a legislative response because public outrage, strongly driven by grassroots activism, they put serious pressure on the federal government. And as a result, in 1980, Congress adopted the Comprehensive Environmental Response, Compensation, and Liability Act, the name that you can see in this slide, or shortly CERCLA, which was then usually referred as Superfund. The idea behind this CERCLA was to deal with what you might call the toxic legacy or past industrial activity. It gave the EPA, the environmental agency, a federal agency, the authority and crucially the funding to identify and clean up these hazardous waste sites. So, in terms of funding, it created a trust fund. And this trust fund initially had about $1.6 billion, and it was largely financed through taxes on the chemical and petrochemical industries. And on the liability side, it followed a fairly strict polluter pays approach. What does this polluter pays approach mean? Well, simply it means that a wide range of actors like current owners, past owners, and even waste generators, they could be held responsible for cleanup costs. Now, for the purpose of this course, uh, what really matters for us is the tax side of this system, something that we will get into more from the WTO and GATT perspective. So we need to unpack why those taxes were imposed and what kind of incentives were behind it. From a policy perspective, the United States was actually dealing with two main concerns. The first one was that there was the need to secure a stable and reliable source of funding for cleanup activities without relying entirely on general public revenues. And secondly, the risk that imposing costs on domestic producers might push polluting activities abroad. So the motivation was not very purely environmental. Why? Because there was also a clear financial logic here, right? So, I mean, raising funds and competitive or industrial logic, basically maintaining a level playing field, right? And it's precisely this combination that explains why the tax system was designed the way it was. So, in terms of structure, we were dealing with two distinct types of taxes. The first one was that there was a tax on petroleum and what are called feedstock chemicals. So this tax was applied directly to specific raw materials. And this was regardless of whether they were produced uh, domestically or imported. And it functioned as a classic internal tax, not something strange, right? And secondly, and this is actually more important, there was a tax exclusively on imported substances. And this applied not to the raw materials themselves, but it was imposed on imported goods that had been produced by using those same taxed inputs, those feedstock. So the key distinction here is that the first tax operates at the level of inputs, I mean at production or import, while the second operates as a kind of a border tax adjustment, and it was aiming to transfer the tax burden that was embedded in inputs onto imported final products, right? So that foreign producers, they could not gain a competitive advantage simply by avoiding the upstream tax. Moving on, so I think this example can really help here. In the end, it's not harmful if or low students practice a bit basic chemistry. So the feedstock chemicals are essentially those basic industrial chemicals, things like this benzene that I mentioned just earlier, a couple of slides ago. And you can see again this molecule. If I pick this laser, so this is the benzene, right? You see the name as well. So as I said, these basic materials, they function as building block in a wide range of chemical processes, right? Now, back to our tax story. These basic materials were taxed because they are either hazardous in themselves or they are used in producing chain that generate hazardous waste. So in this case, as I said, benzene is actually used as a hazardous material. So taxing it could make sense both environmentally in terms of industrializing externalities and administratively because they are relatively easy to identify in especially at an upstream stage, right? But by contrast, imported substances refer to finished or semi-finished goods. This is like the finished product or those semi-finished goods and components, right? Those who were made from the feedstock. So these are things like certain plastics, resins, or more complex chemical products, right? So, for instance, you can see here how we produce another substance called styrene, and this is actually produced indirectly. I didn't want to bring the whole chemical process, but the point here is that we produce styrene from benzene, and you see that how similar the molecules are, right? And then after another step, we produce a polymer that is named polystyrene, from which again you can produce different materials like this styrofoam that among different application, one of its grades is used to produce these food boxes, right? So now it's like the US decided to impose tax on the styrofoam. I'm not saying that if actually they did it, but just hypothetically in an example. So these final products or the mid products, they were deliberately treated separately because otherwise foreign producers could simply export the finished products instead of the taxed raw material and effectively bypass the tax, right? If we were in the situation like exporting benzene to United States, would face some tax, but styrofoam or polystyrene not, then obviously it would be beneficial to convert benzene to styrene or polystyrene and then export it to the US to evade the tax. But in order to prevent it happening, then the US legislators, they decided to do so, right? So it is very important that these products are not necessarily like the domestic feedstock. They sit at a different stage of production chain, and they are better understood as downstream products rather than directly comparable goods. And from an economic perspective also, if we look, What what this system tries to do is cover the entire production chain by the taxation rules and regulation, right? So upstream production of the feedstock is taxed directly, and downstream foreign product is brought into the system through the tax on imported substances. Now, the idea is to create a consistent price signal across the chain, and that's very important here. So that environmental costs are reflected in final prices, while at the same time preventing any competitive advantage that might arise from producing abroad without bearing those costs. But in practice, things actually got complicated. Why? Because determining how much of a given feedstock is embedded in an imported product is not always straightforward. And that's where problems started to emerge. So, what do I mean? Look, in reality, not all importers were affected in the same way because industries producing standardized goods with clearly defined compositions, they could demonstrate their actual tax burden more easily, right? But what about those industries with more complex or less transparent production process? You see here how straightforward the production of this styrofoam could be from benzene. Of course, again, I made it much easier than it is. But even if we add other components here, it was more or less straightforward. But chemical processes are not always like this. So when it comes to those industries, they were more exposed to the use of presumptive or estimated values that were defined by US authorities. And those estimates could be very conservative. I mean, they might assume higher input usage than actually occurred, which in turn could then lead to a higher tax burden, right? That was higher comparable compared to domestic productions, right? So the impact was uneven at the end, and certain countries and sectors, particularly exporters of processed chemical products, were more vulnerable. And it was precisely this uneven and potentially excessive burden that triggered concerns among trading partners. And afterward, a number of countries, including especially Mexico and European communities, the father of European Union that time, challenged those measures under the GATT framework, arguing that they distorted indiscriminative conditions in the U.S. Market. So, okay, so moving forward with the legal perspectives. The complainants, I mean, this Mexico along with the EC, they argued that this tax regime was inconsistent with Article 3, Paragraph 2 of GATT, both under the first sentence and the second one. So, respectively, they argued that on the first sentence, as it says that the products of the territory of any contracting party imported into the territory of any other contracting party shall not be subject to internal taxes in excess of those applied to like domestic products. And obviously, I shortened the original one. And under the second sentence, again a shorter version, no contracting party shall otherwise apply internal taxes to imported or domestic products in a manner contrary to the principles set forth in paragraph 1. And they also relied on Article 3, paragraph 1 of this overarching principle. Now, The core of their claim, and this is actually really the key takeaway here, was that in practice, imported substances were sometimes being taxed more heavily than the equivalent domestic tax on the inputs that were used to produce similar products, especially because of the way that the US was calculating those taxes, something that I explained to you already in previous slides. So, on the evidentiary side, the complainants they basically advance a two-layer argument. Firstly, they said that uh, as a matter of law, the structure itself it allows the use of default values or estimations methods. That's the de jure angle. And then they reinforce that by bringing in practical examples showing that in real situations, those methods that we discussed, right? Those methods can actually result in over taxation of imports. And that's the de facto side. So the takeaway here is that the law is not explicitly discriminatory on its own, but the way it is applied can still produce discriminatory effects, right? And building on this, Mexican's perspective was that the US policy is actually very protectionist element that is sitting in the that Superfund law, right? And this is especially because if the importer cannot demonstrate the exact input mix, then the US authorities would rely on higher assumed values, as I explained earlier. And this can translate into a higher tax burden for those specific importers. And the practical effect of this way of implementing that principle of border adjustment gives the domestic producers a competitive edge, even if that was not the stated intention behind the measure, even if the US authorities did not aim to, even if they wanted to protect the environment. And that's the point here, right? So then, after hearing their argument, one can ask, what was the panel's idea about this? It was actually quite explicit in the panel's report that they said the taxes on feedstock chemicals are consistent with Article 3.2 because they argued that because these are applied equally to both domestic and imported products. So no problem with those taxations on the feedstocks, right? Because obviously they are the same way they are applied. Like for example, if you use 1 ton of benzene in producing some material, you have to pay this amount of tax. If you are importing that, you have to pay the same tax in order to reach the shelf, right? So then there is no discrimination on this. But when it comes to the imported substances, the panel takes a very nuanced position because it accepts in principle that such tax is permissible provided that it is strictly equivalent to the internal tax burden on domestic inputs. But the moment that equivalence breaks down, you move into the territory of violation. If you look more closely at this whole reasoning, what the panel was doing was adopting a layered and I can say differentiated approach because it does not treat the tax system as a single block. but instead it disaggregates this whole issue and evaluates each component separately. So, on the one hand, for petroleum and feedstock chemicals, the complainants' claim are rejected because no inconsistency was observed with Article 3, Paragraph 2, right? As we explained. But on the other hand, for imported substances, the panel accepts the basic idea of mechanism, but finds that certain aspects of its application are inconsistent with GATT. And that is actually why the outcome is best described as a partial violation. A partial violation, but not a full rejection of the complaint. So, looking specifically at why the claims fail in relation to a feedstock chemical, the panel frames the analysis under the first sentence of Article 3, Paragraph 2, and asks a very straightforward question. It was like this: are imported products being taxed in excess of like domestic products? The answer is no, right? Because the same tax rate applies across the board with no textual or practical differentiation. So in that sense, the panel treats it as a classic internal tax applied in a neutral manner. And as a result, it does not identify any protectionist element. But by contrast, the real issue with imported substances was observed. Because here, the complainants, they argued that the tax as applied results in a higher effective burden on imports than on domestic products. So, in a way, the panel begins by clarifying that this kind of tax adjustment is not per se illegal because a country is allowed to extend internal tax on input to imported products, right? But, and here this but is crucial, if they want to impose such a tax, it must be precise equivalence, not just an approximation that overshoots. So, if I want to put it more precisely, when the panel examines how the United States actually calculated the tax, it finds that in many cases, the authorities, they relied on presumptions or estimations and use them as the method due to the lack of precise data on the composition of imported goods. So these methods could be based on maximum possible input that was used or conservative assumptions, and the result of this obviously was like an importer might end up paying more taxes than that would be imposed on domestic products. So as a result, at this point, the panel concluded that the not in excess of requirement that is under Article 3, Paragraph 2 is breached. So again, the problem is not the environmental tax by itself. It was the way it was operationalized. And here I also want to add one point on the discrimination issue, because the panel's reasoning is much closer to a de facto analysis, right? The law on its face does not explicitly impose higher taxes on imports, so there is no clear de jure discrimination. But the structure and especially the administration of the tax, particularly its reliance on estimations, could potentially produce discriminatory effects in reality. And this is sufficient for a finding of inconsistency, because this Article 3 is actually concerned with actual competitive condition, not just the formal wording of the measure. So if you pull all this together, the legal outcome is quite precise. Firstly, taxes on petroleum and feedstock chemicals are GATT consistent. Secondly, the concept of taxing imported substances is in principle acceptable. And thirdly, by the way that the tax is applied in certain instances, that can violate, and in this case, it actually violated Article 3, Paragraph 2, because it could lead to overtaxation of imports. And at the end of the day, one can say that in terms of consequences, the United States actually effectively had to adjust its methodology. So this methodology was revised to ensure that the tax burden on imported substances did not exceed the equivalent domestic burden, to move it toward more accurate and transparent calculation, and reduce reliance on broad pre-assumptions. And the broader doctrinal takeaway is that the panel is setting an operational standard. You see the point? Because if a state wants to extend an environmental tax to imports, it must demonstrate a true mirror of the internal tax. I mean, any deviation from that equivalence, whether due to lack of data, administrative shortcuts, or conservative assumptions, risks being characterized as protectionist under GATT, regardless of the environmental intent behind that measure. So that was all. I hope you find this helpful to better understand the CBAM case that we discussed thoroughly in our lecture. And until next case, have a good time.